So good day, everyone, and welcome to the Farmers' Rights and the International Treaty on Plant Genetic Resources for Food and Agriculture webinar. My name is Titilayo Adebola. I'm a lecturer in law at the University of Aberdeen, and in that capacity, I am organizing this webinar alongside Afronomics Law, a blog on international economic law, and Flora IP, an innovative food, agriculture, and intellectual property law resource. This webinar is the second of a two-part series on farmers' rights. The first webinar held yesterday, it was titled Farmers' Rights in the International Legal Architecture for Food and Agriculture. Our focus today is on the International Treaty on Plant Genetic Resources for Food and Agriculture, hereinafter International Treaty. We have 6 distinguished panelists to give us insights and first-hand perspectives on farmers' rights. We have the Secretary of the International Treaty, Mr. Nnadozie, who is going to give us an overview of farmers' rights in the International Treaty. We have Suyar Adikari, a farmer and chairperson, Participatory Plant Breeding Group, POKHARELI Municipally in Bengas. We have Mr. Salvatore Cesarali, consultant, participatory plant breeding expert. His topic is participatory plant breeding and farmers' rights. We have Mr. Kamalesh Adikari, research fellow, University of Queensland. His topic is a critical analysis of farmers' rights, lessons from Nepal. We have Mr. Rakesh Agrawal. He was the former Registrar General of the Protection of Plant Varieties and Farmers' Rights Authority in India. He's going to talk about farmers' rights and India's protection of Plant Varieties and Farmers' Rights Act, law and practice. And finally, we have Ms. Miriam Mayet, the Executive Director, African Center for Biodiversity. Her topic is farmers' rights and the farmers' seed systems. In our discussion yesterday, we set out the context and the mapping of farmers' rights. We established the historical background of farmers' rights. So we could trace farmers' rights back to the work of Kari Fowler and Pat Mooney and the discussions around the asymmetry in the international legal landscape for plant varieties. So there were the discussions that when Plant Variety Protection or Plant Patent Act was introduced in the United States in 1930, and around Europe, there were divergences in protection systems. So we know that the United States introduced the Plant Patent Act 1930. Around Europe, there were different perspectives. Some countries had patents for plant varieties. Some countries had sui generis systems. Those systems harmonized with the creation of the International Convention for the Protection of New Varieties of Plants, UPOV, in 1961. Thereafter, many countries around the world had started introducing plant variety protection systems, which have a close affiliation and link with farmers' rights. We saw a cementing of that with the Article 27.3b of the Agreement on Trade-Related Aspects of Intellectual Property Rights, the TRIPS Agreement, which obliges all member states of the World Trade Organization to introduce plant variety protection systems. One of the questions that was debated then at the TRIPS Agreement was what type of system should the plant variety system be incorporated in that treaty? But there was no consensus, so countries had different perspectives. Like we said, the United States had gone all the way to providing patents for plant varieties. So with laws like Diamond versus Chakrabarti in 1980, ex parte Hebed, and GMM supply pioneer hybrid, there was the introduction of patents to plant varieties. However, Europe maintained the absence of patents for plant varieties and maintained that the system should be a sui generis system. So we have Article 53b of the European Patent Act, which prohibits patents for plant varieties as such. Now, the contestation at the international level was, what about farmers? What types of protection systems should we give farmers? We had the innovation and the discussions around this with the new international economic order. And we then had discussions moved to the United Nations. So the Food and Agriculture Organization of the United Nations was deemed to be the relevant platform to accommodate these discussions. So we had the International Undertaking on Plant Genetic Resources, which was a non-legally binding instrument. We had resolutions during after, so we had resolution 481, 581, 89, so 489, 589, 391, which introduced farmers' rights. But this was cemented with the adoption of the International Treaty in 2001 and its entry into force in 2004. But the conundrum still remains, what are farmers' rights? So the international treaty in Article 9 leaves national governments to decide their interpretation of farmers' rights. This can be both a limitation and a potential. A limitation in the sense that some national governments have not decided the rationale or the mode of protecting farmers' rights. However, we have countries like India, which is represented here, that has created an imaginative interpretation of farmers' rights with the Plant Variety Protection Act. We also had the Africa Model Law, which clearly sets out the interpretation of farmers' rights to include community rights, traditional knowledge, etc. Our task here today is to provide first-hand perspectives on different case studies on the interpretation of farmers' rights and to envision what a future of farmers' rights perhaps would look like. The aim of this webinar then is to disseminate knowledge and information around farmers' rights and to create more awareness around the subject. Our structure for the day would be to start with our panelists. Our panelists will have 10 minutes each to present their positions on farmers' rights. Thereafter, we would have 2 minutes for a discussion based on their presentation, and would open the floor to conversations and discussions with our participants. I would invite you to kindly put in the questions that you would like to ask our participants in the chat function. Please include your full name and your institutional affiliation. I will read out the questions and direct them to the participants, to the panelists. If you have any panelists that you think is best suited to answer your questions, please do feel free to include that in your questions in the chat function. I'll invite all our participants to also please keep their microphones on mute, and just so that we can ensure that we have a clear audience and a clarity of the presentations from our panelists. Thank you very much for joining us in this webinar today, and I look forward to our robust conversations. We'll start now with the Secretary of the International Treaty, Kent.
Thank you so much, Titi, for that introduction, and I'm glad to join you today for this discussion. The first caveat is that my presentation does not include any interpretation of the treaty or any provisions of the treaty, but just an explanation of the provisions and what we have been doing as a secretariat and some of the key decisions of the governing body that are relevant for your discussions and the stakeholders in this regard. So I'll have a presentation that I'll make. I hope I can conclude that in a matter of 10 minutes that you've given us. Is that displaying now? Yes, okay, thank you very much. So what I'm going to do is this overview of the provisions of the international treaty that are of relevance to farmers' rights. Well, first, I would have to start with the key objectives of the treaty. Some of you are aware of it if you had participated yesterday in the webinar of yesterday. You would have become familiar with some of these provisions, the key provisions and objectives of the treaty that mirrors the provisions and the objectives of the Convention on Biological Diversity are mainly to conserve, sustainably use, and share the benefits from the use of plant genetic resources for food and agriculture in harmony with the Convention on Biological Diversity. So in brief, in a broader scale, the treaty aims to ensure that the seeds and the plants that form the basis of our food systems and agriculture are fully conserved and used sustainably, and that the benefits are shared, and the farmers who have contributed towards its development, preservation, and conservation are able to benefit from those from their contributions. So essentially, the treaty, in addition to being a legally binding framework, also facilitates provides a platform or forum for further discussion, negotiation, and decision making among the contracting parties. It provides a global forum that addresses some of the key challenges that we are facing these days, which includes the loss of diversity, which is increasing at a high scale, the challenges of climate change, ensuring that we have diversity that meets the new environmental as well as climatic changes that are happening, and the nutrition needs of the ever-increasing global population. At the moment, there are 147 contracting parties in the European Union that have signed on to the treaty. that gives you an indication of how the kind of importance that contracting parties and countries all over the world place on this treaty and its provisions. So essentially, while the treaty has so many components that range from the access and benefit sharing, multilateral system, information systems, funding strategy, one of the key and critical components of the treaty is contained in the Article 9 of the treaty, which, of course, I'm sure many of you become familiar with, who have been following the topic, which essentially recognizes the contributions that farmers have made for millennia and will continue to make. Essentially recognizing the pre-existing rights and the pre-existing, contributions that they have made, recognizing that. And it gives an indication or indicative list of such rights, which includes the protection of traditional knowledge that are that are relevant to plant genetic resources, the right to equitably share benefits arising from the use and development of plant genetic resources, also the right to participate in national decision making, which essentially ensures that they have sufficient political space to make contributions and be part of the decision-making processes in their national and local government and scene. So, but then the treaty provides that the actual implementation of the treaty, lies on the national government to be able to realize those rights, and enjoins them to take measures, including legislative, policy, administrative measures to promote and protect those rights. So Article 9 of the treaty and the farmers' rights provisions it that the treaty, international treaty, is essentially the first internationally binding agreement to formally recognize those rights, while giving responsibility to national government to implement them through provisions as I've seen. But the treaty essentially recognizes that farmers are primary constituency of its provisions and should be primary beneficiaries of the activities and developments and benefits that arise from use of genetic resources that have contributed to and have been custodians of for millennia. Titi has also indicated that the background is to establish a balance between the rights of breeders who are entitled to benefit from the investments and innovation against the rights of farmers who have also contributed and have provided some of the raw material that form the basis for the development of new varieties. So this graphic shows you the layout of the rights. I mean, in no particularly, precedence, but Article 1 essentially is a recognition of those rights for sure. And then Article 9.2 also then stipulates the elements or indicative list of such rights, as I've indicated, which is protection of knowledge, equitable participation in sharing of benefits, decision making, and also Article 9.3 talks about their right to save, use, and exchange and sell farm seed and propagating material. And this is, of course, subject to national law and as appropriate. This is in line with the recognition that the implementation lies with national governments and national systems. So there are some key decisions in the course of implementation of the farmers' rights. The governing body has recognized that it is a key provision that requires, robust implementation along with the other provisions of the treaty. And since then, since the treaty came into force, there have been a number of decisions that are relevant. Most of that had been essentially process of collecting, collating and sharing experiences and information and knowledge about how countries, stakeholders, and other actors are implementing farmers' rights. So over the years, we've collected quite a lot of information and experiences that are involved in implementation. And then having done that, it went on in 2017 to establish an ad hoc technical expert group on farmers' rights. This was the first formal, I would say, intersectional process or subsidiary body that had established to start looking at elements of the farmers' rights. Then having the ATEG, which is the Ad Hoc Technical Expert Group on Farmers' Rights, we gave them very specific mandates, which of two of them. First, based on the information that have gathered over the years and further submissions that are made by contracting parties and stakeholders. The ATEG was mandated to produce an inventory of those measures, which will include best practices, lessons learned from the implementation and realization of farmers' rights as set out in Article 9 of the International Treaty. So from then on, the ATEG met several times to carry out this task. The second task involved, well, of course, once they've developed the inventory, based on that, to develop options that would encourage, guide, or promote the realization of farmers' rights as set out in the article, under Article 9. This essentially will be based on the inventory and submissions that have been made by the countries and stakeholders. So having done the first part of their tasks at that time, so they went ahead to provide this to the governing body, and the governing body welcomed and endorsed that the inventory, and also asked the secretary to go ahead and establish an online version, and that we have done right now, and in due course will be made public. This inventory is subject to continuous improvement, and revision, and additional experiences could be added to it, and revisions when there are changes done to it. So then, because of time, resources, and the volume of work that he had, it wasn't possible for them to conclude their assignment before the 8th session of the governing body. So based on the need to really conclude those tasks, the governing body reconvened the ATEG for it to be able to finalize its tasks. And then, which now is the development of the options, as you can see. So as a secretariat, I mean, we've been doing quite a bit as well, in terms of not just because there are very specific tasks that the ATEG is supposed to be doing, but in general, as a secretariat, we are obliged and tasked with implementing the comprehensive implementation of the treaty and all the provisions of the treaty. So in that regard, also based on the specific request of the governing body, we continue to facilitate the work of the ATEG, continue to gather information, gather measures, best practices, and share that information, providing the platform for exchanges, and then facilitating, contracting party stakeholders who have, who are engaged in capacity building or information dissemination and exchanges, just like the one that Titi is organizing now, so that we are available to partner with any stakeholder or any contracting party that wishes to engage in other capacity building or information dissemination as required, as necessary under the Article 9 of the treaty. So we also develop communication materials as far as training and education models and material. So that's it in brief. Hope I've kept to time, more or less. Okay, maybe a few seconds beyond 10 minutes. But thank you so much for this, and I'll be quite glad to answer any questions that you might have, because this is a very abridged version of the whole expanse of work that we've done and that is going on with regard to farmers' rights. So thank you very much, Titi, and over to you.
Thank you so much, Kent. And that was an excellent overview of the work of the Secretariat of the International Treaty. And just to be clear, I want to just state that this webinar is distinct and different from the work of the Ad Hoc Technical Expert Group. I was supposed to say that at the offset. So thank you very much for that, Kent. And I think you've raised excellent points around the work of the International Treaty, setting, like I mentioned in the introductory part of this webinar, that one of the key points of the Article 9 is that it leaves it open to national governments. So the work that the Ad Hoc Technical Expert Group is undertaking now is to help governments, national governments that are interested in seeking ways to implement farmers' rights, to have examples and just templates on how to build or implement the provision. So thank you very much for clearly setting that out and for starting us off in our conversations today. Next, I will share the presentation from our farmer who has a pre-recorded presentation today, and I'm just looking for it now. Okay, so I think let's go to Salvatore first, and then we'll play the recording next. So Salvatore, you're on mute, please. You're on mute, please.
Can you hear me?
Yes, we can hear you.
Okay. Good afternoon. Thank you very much for inviting me to this webinar. And coming immediately after the secretary, I should point out that participatory plant breeding is very much part of the treaty. Probably you have noticed that Article 6 is speaking specifically of participatory plant breeding when it says promoting as appropriate plant breeding efforts which with the participation of farmers, particularly in developing countries, and so on. So what is participatory plant breeding? First of all, let me share with you a slide showing what is plant breeding. Can you see it? Plant breeding is a circular process which starts with defining what the objectives are and what the target group is, with setting the priorities, then by generating a lot of diversity, usually by crossing. This is followed by several cycles of selection, which end up with a few selected potential varieties, which are tested, and then the best varieties are released as cultivars, certified seed is produced, and all the process is based on the hope that farmers will accept the final product and will adopt the varieties. Now, all this process is run by scientists, traditionally without talking to farmers, and within one or few research stations. Participatory plant breeding is exactly the same process, except that instead of being run in a research station, is run in farmers' fields, in several farmers' fields, with a full participation of farmers in all the key decisions, with the same level of right. So the opinion of the farmers and the opinion of the scientists in taking decisions has the same weight. So the process, by changing in this way, becomes theoretically based on the decentralized selection. This is an example of what we were doing in Syria, where we started the first participatory breeding program with barley. As you can see, I was sitting in an international center, which is this yellow spot. We were collaborating with the Ministry of Agriculture, which are the stations are these blue spots, and the brown spots are the villages. Now, the essential difference between participatory and conventional plant breeding is that the decisions are taken at village level jointly by farmers and scientists, independently, village by village. So automatically it's easy to understand that the system is promoting diversity, because even if you start for the same set of, let's say, 200 breeding lines, because of differences in soil, differences in agronomic management, differences in climate, differences in farmer preferences, in different villages, almost inevitably, farmers will select different varieties. So scientifically, as the same value of the program which is run in research station. I published a paper about 5 years ago in crop science where I demonstrate that actually if you define efficiency from the point of view of adoption, increase in diversity, and cost effectiveness, a participatory plant breeding program is much more convenient, much less expensive, particularly if you consider the ratio between cost and benefit, and at the end is much more efficient than a conventional breeding program. As I mentioned, because farmers are involved in the process, adoption is greatly increased. Farmers will never select something that they do not like. It generates diversity, is gender sensitive. You see, diversity is always part of plant breeding, but in conventional plant breeding, the initial diversity is transformed into uniformity, while in participatory plant breeding is maintained because selection is decentralized. And the other aspect is much easier in a participatory program to be gender sensitive. In each village, we have a gender specialist working with us. And you see, in this case, in the bottom part of the picture, you can see that we were collecting samples from the field because these women in this village could not come out of the house. So we brought a crop into the house and they could do the selection. Every bag, of course, was numbered. Then, because of this participation in all the aspects of the program, participatory plant breeding has a very strong empowerment effect. Of course, I should mention that with this increase in diversity, it creates at country level, but also at international level, much more resilience towards climate changes that the conventional plant breeding, which generates uniformity, can do. I should mention at this point one aspect of climate change which is not always mentioned sufficiently clearly. Climate change is not only temperature and rainfall, because with temperature and rainfall, we will have changes in diseases, insects, including pollinators and weeds. And these changes are largely unpredictable and location specific. So that's where a decentralized breeding program, such a participatory program, becomes of major advantage. Unfortunately, after running participatory breeding programs in several countries in the Middle East, North Africa, the Horn of Africa, and Asia, generally speaking, institutions, including the CG institutions, have been very reluctant in accepting participatory plant breeding as the way, the main way of doing plant breeding. Recently, with my wife, we did an inventory, which has been published last year, and we found that in the last 40 years or so, participatory plant breeding has been done in 69 countries, 10 of which developed, on 47 crops. So there are no limitations. These are self-pollinated, cross-pollinated, and vegetatively propagated crops. But there has been a change. In the first 20 years or so, most of the research on participatory plant breeding was done in the CG Center, and in the CG Center, while in the last 20 years, perhaps as an effect of the change in the donors to the CG centers, most of the work on participatory plant breeding has been actually done by universities, which shows that is a scientifically based process. Particularly, American universities are very active in participatory plant breeding, particularly thinking about organic agriculture, and by several NGOs. I would like to conclude that participatory plant breeding, which in some circles is criticized for bringing science backwards, is actually fully compatible with molecular breeding. The moment the farmers tells you that they like very much to incorporate a certain trait, knowing very precisely the genetics of that trait can be very helpful in organizing the material so that the frequency of genes controlling the trait is increased in that population. And eventually, one of the great benefits of participatory plant breeding is that it brings back in farmers' hands the control of seed. Because of course, a decentralized breeding program which generates so much diversity, so much diverse varieties in different parts of the country, with a tremendous diversity in space and time, can be is very difficult to be served by a centralized seed system like big seed companies. And therefore, the only way to enjoy fully of the potential benefit of participatory plant breeding is for the farmers to become again the seed producer. So we have these pilot villages where we had a group of 10, 15 farmers participating in the program. Some of them became also seed producer. And the rule was that all the farmers who participated in the selection has free access to the seed, while the seed can be sold outside the village or outside a group of villages to other farmers who then potentially could become also participants in the project. So the bringing back the seed control to the farmers' community is another major benefit of participatory plant breeding. Thank you.
Thank you very much, Salvatore. So that was excellent. One of the perennial and recurrent questions around farmers' rights is, are farmers breeders? Can farmers breed farmers' varieties? And you've been able to show us that participatory plant breeding involves farmers breeding of farmers varieties, and that those varieties have benefits, wider benefits to our agricultural space and to our soil and to our land and to sustainability of agriculture. So thank you very much for that. I will try again to see if I can share my screen. And this is a presentation from Soha Adikari, and it's titled A Farmer's Perspective on Farmers' Rights.
म सूर्य प्रसाद अधिकारी कास्की जिल्ला लेखनाथ म सूर्य प्रसाद अधिकारी कास्की जिल्ला लेखनाथ पोखरा महानगरपालिका वार्ड नम्बर 31 डेग्नस गाउँ। म एकजना सानो कृषक हो। मेरो जमिन 19 रोपनी छ। म पर्माकल्चर विधिबाट खेती गर्छु। म प्राङ्गारिक कफी उत्पादन गर्छु। म 23 वर्षदेखि धान बाली प्रजनन र रैथाने बाली संरक्षणमा संलग्न छु। यी विषयमा म कृषक र समूह र समुदायलाई तालिम दिन्छु र प्रेरणा जगाउने काम गर्छु। धान बाली प्रजनन कार्यक्रम मैले विभिन्न रैथाने धानहरूका बीज प्रजनन गरिरहेको छु। घैया र काठेगुर्दीको क्रस सुक्खा सामान्य जात विकास गर्नका लागि गरिएको हो। यसबाट दुईटा जात विकास भएका छन्। पोखरेली जेठोबुढो र एक्लेको क्रस एक्लेमा बास्ना आउने बनाउनको लागि गरिएको हो। यसबाट एक जात विकास भएको छ। एक्ले र मन्सुली क्रस स्वादिलो र बढी फल्ने जात विकास गर्नको लागि गरिएको हो र यसबाट पनि एक जात विकास भएको छ। धानका रैथाने जातहरूको विविधता प्रदर्शनी स्थल। हामी प्रत्येक वर्ष धान 47 रैथाने जात र 5 वटा PPVबाट विकास भएका जातहरूको विविधता प्रदर्शनी स्थल स्थापना गर्छौं। यसको मुख्य उद्देश्य रैथाने बिउ जोगाउन र युवा पुस्तामा चेतना जगाउनु रहेको छ। भविष्यमा गरिने अनुसन्धान र विकासका लागि माउ उपलब्ध गराउनु पनि हो। दर्ता प्रक्रियामा रहेका धानका रैथाने जातहरू। यो गाउँ तथा वरपर खेती भइरहेका धानका रैथाने जातहरू मध्ये 5 वटा उत्कृष्ट रैथाने जात छनौट गरेर राष्ट्रिय बिउ बोर्डमा दर्ता गर्न प्रस्ताव पेश गरेका छौं। हामी यी जातहरूमा समुदायको अधिकार स्थापना गर्न चाहन्छौं। यी जातहरूको अनुसन्धान तथा प्रस्तावना लेखन कार्यमा हामीलाई लिबर्ड र राष्ट्रिय जिन ब्याङ्कले सहयोग पुर्याइरहेको छ। दर्ता प्रक्रिया रहेका धानका उत्कृष्ट रैथाने जातहरूको फोटो। एके धान, रातो अनदी, बयर्नी धान, पहेँले र कालो जिनुवा। यो गाउँ अब किन धान बाली प्रजनन र रैथाने जात संरक्षणमा संलग्न छु। यो गाउँ तथा वरपरका कृषकहरूका लागि रैथाने जातको गुण भएका बढी उत्पादन दिन सक्ने धानका जातहरूको विकास गर्न, हाइब्रिड बिउको प्रयोग र यसका नकारात्मक पक्षबाट कृषकहरूलाई जोगाउन, रैथाने जातका कृषकहरूको अधिकार स्थापना गर्न र युवा पुस्तालाई कृषि जैविक विविधताको दिगो संरक्षण तथा उपयोग बारे ज्ञान दिन। बायोभर्सिटी र लिबर्डका बाली प्रजननहरू PPV प्लटमा सन् 2018 को ब्याचका PGR कोर्सका लागि नेपाल आएका 18 देशका सहभागीहरू PPV बारे जानकारी लिँदै बिउमा कृषक अधिकार। हालसम्म पुस्तौँदेखि कृषक तथा कृषक समुदायले कृषि जैविक विविधता संरक्षण तथा उपयोग पुर्याएको योगदानको उचित कदर भएको छैन। हालसम्म राष्ट्रिय सरकारको सूचीमा कृषक अधिकार प्राथमिकता परेको छैन। यसमा ध्यान पुगोस्। रैथाने जात कृषक विकास गरेका जातको दर्ता प्रक्रिया एउटै छ। यो उपयुक्त होइन। हाम्रो खाद्य प्रणाली कृषकको परम्परागत बिउ प्रणालीमा आधारित कुनै पनि व्यक्ति वा निकाय यसको विरुद्ध सोच्नु पनि हुँदैन, किनभने साना कृषकहरूको कम्पनीले उत्पादन गरेको बिउ र खाद्यान्न खरिद गर्न सक्दैन। धन्यवाद।
Okay, so that was the presentation by Mr. Suha Adikari, and there he's making a case for the protection of farmers' varieties. He's showing us the rice varieties that he's been able to breed with his farming community, and he's explaining why those the farming community should have intellectual property protection for their variety. So a related concern to this is the seed sector. An explanation of the formal seed sector is that in many countries, you need registration of your seeds for commercialization in the seed sector. So any variety that is not registered in the seed sector would not be formally commercialized. So one of the cases that he's making is for the registration of these farmers' varieties in the formal seed sector and the commercialization of those varieties, but he's also asking for intellectual property protection for those farmers' varieties. And he's asking that the level of protection for the farmers' varieties developed by farming communities and small-scale farmers should differ because of the different levels of social and economic capacity and positions that they have. Next would go to Mr. Kamalesh Adhikari, who is going to give us also a case study on Nepal. So I think that this nicely fits in because he's able to expand on some of the work that Soha and the communities there have done on breeding new varieties. Kamalesh, please.
Thanks, Titi. Thank you so much for this opportunity. Let me share the screen first so that I can show you my slides. Is it displaying well now? Yeah. Okay, thanks, Titi. And I think it's been quite a long time that I hadn't been able to meet Surya, who is also from my country, Nepal. And I had the privilege of working with him in several occasions. And in fact, Surya, who just spoke about the entire breeding work that he's doing in Nepal, I had the chance to visit with him and participate in an international global consultation on farmers' rights in Ethiopia in 2010, I think. And I acted as the translator for Surya at that meeting. And so I was going through lots of memories when he was talking about breeding program in Nepal and all those things. So I think my presentation builds upon what Salvatore initially talked about participative plant breeding, and at the same time, what Surya Adhikari talked about how farmers in Nepal are trying to protect their varieties through participative plant breeding and through official registration under some kind of seed law or something like that. So, but in the meantime, when I try to build upon what they have initially said, I would also like to say that my presentation is going to be a bit different because I'm going to talk mostly about some of the questions and concerns about the protection of farmers' varieties that have rarely been addressed in many of the domestic laws that so far have been developed in several developing and least developed countries, and including in many advanced countries, in fact, in many developed countries. So that is one of the key contributions that I would like to make through this project presentation. And in the photos that you would say that I will be talking about a case study of a traditionally grown rice variety, as you can see, and then based on my own field work that I did in Nepal for several years, in fact, about which I will talk a bit later. So to just give you a context about what I want to present today and why I want to present today, I would like to say that so far, if we look at how developments are taking place within the International Plant Treaty, then we see that there exists significant focus on identifying options, mechanisms, and approaches to protect farmers' rights to plant varieties. But what actually are farmers' varieties? What do we mean by farmers' varieties? What are farmers' varieties, So we really have really clear-cut answer to that question. And there are certain legal and taxonomic problems in terms of identifying these varieties, and which have already been identified as one of the key problems also by some of the previous scholars. The second thing that I would like to emphasize is countries such as India and Thailand have developed laws and technical criteria to categorize and protect farmers' varieties as intellectual property. But what will be the legal status of farmers' varieties after their protection periods end? Like, for instance, India provides protection to farmers' varieties for 15 years. But what will be the legal status of those varieties after that after the collapse of those 15 years, like after the end of those 15 years, you know. So that is also a key issue that I think should be taken into account when we talk about farmers' rights and farmers' varieties. So in this presentation, basically I will use the case study of a traditionally grown rice variety and a participatory plant breeding that converted this variety, this traditionally grown variety, into a commercialized variety. And then while doing that, I will try to explore and I will try to answer what does it mean to protect farmers' varieties as intellectual property, you know. And in so doing, as I initially said, I will mostly focus on some of the questions and concerns that relate to this question, like what does it really mean to protect farmers' varieties as intellectual property. So before I really go and talk about my case study, I would like to focus on one important aspect. Like most of the time, when we see many of the literature around farmers' rights and farmers' varieties, then we often get a kind of a confused understanding about farmers' varieties. People talk about farmers' varieties as, you know, like people use the term farmers' varieties as indigenous varieties, traditional varieties, native varieties, local land races, wild varieties, folk varieties, autochthonous varieties, all kinds of varieties, you know. But then for the viewpoint of my presentation and my own research, I have categorized farmers' varieties into two legal categories. So I have category 1 and I have category 2. And under category 1, I would put those varieties like indigenous, traditional, native, and local varieties, including land races, you know, wild varieties, under category 1. And I argue that these varieties could be used as source germplasm for the breeding of another variety. And under category 2, I would include farmers' varieties. So these are the varieties which originate from category 1 varieties, which means that if you, like if Salvatore breeds category 1 variety for some kind of improvement through breeding, then he, through the employment of participatory plant breeding techniques, he would come up with category 2 varieties. That is a new farmer's variety, a farmer breed new variety. So I would like to make that clear distinction before I really start talking about that case study. So what is so special about category 1 plant varieties is that these varieties are like indigenous, traditional, native, and local varieties, that these varieties are often characterized by genetic heterogeneity, and then they may be protected under the domestic access and benefit sharing or seed laws. But what is so special about category 2 varieties, like farmers' varieties, is that because these varieties are, you know, because these varieties are newly bred varieties from category 1 varieties, so they may meet the criteria of, you know, distinctness, uniformity, and stability, because these have been bred through participatory plant breeding or some other evolutionary plant breeding or some other breeding methods or even farmer selection methods, and these can be protected under plant variety protection laws. So that is the clear distinction that I would like to make before I really start talking about, because when I will be explaining my case study after this, then I will be using this category 1 and category 2 to explain why this really matters. So to talk about my case study, I think it is really important that I highlight here that I've done a case study of a rice breeding program, participatory plant breeding program that was implemented in Nepal long time back from 1997 to 2005. And that breeding program was employed to develop a traditionally grown rice variety called JETHOBUDHO, POKHARELI JETHOBUDHO. And in these pictures, you can see that initially I conducted that field work in 2008, long time back. That's the picture on the left. And on the right, you can see another picture where I have done field work in 2018. So all of the findings that I'm going to talk about based on this study relates to this field work. So JETHOBUDHO was one of the oldest traditional rice varieties which farmers of the Pokhara Valley of Nepal were growing at an altitude of 600 to 900 meters above the sea level. In 1997, after local farmers reported that JETHOBUDHO had begun to underperform due to certain problems with agronomic traits, a group of national and international actors designed a participated plant breeding program. Between 1998 and 2005, the program spent a good amount of time and resources to evaluate and improve the agronomic as well as post-harvest traits of JETHOBUDHO. In so doing, the program first collected 2 sets of 338 lines of JETHOBUDHO from farmers of 11 different sites. And from 2000, the program started to experiment with these lines in 2 local sites of the valley. In 2003, the program narrowed down the selection of JETHOBUDHO accessions from 338 lines to only 6 locally preferred lines. So that was done through the selection method. Since then to 2005, the composite variety of 6 lines was planted by a wider group of farmers, and it was noticed that the grain yields increased from 2.4 tons per hectare in 1999 to 3.24 tons per hectare in 2005. Also, the composite variety provided greater resilience to local growing conditions, including tolerance to blast disease and lodging, while maintaining favorable post-harvest traits such as aroma and taste. After a favorable evaluation in After a favorable evaluation in the composite variety, which emerged as traditionally grown variety, was registered under the National Seed Act as a multi-line enhanced variety, and then it was given a new name. It was not just known as JETHOBUDHO now. So the new name was POKHARELI JETHOBUDHO because it was the variety developed by POKHARELI farmers of the Pokhara Valley. So the variety was registered, but interestingly, the variety was registered in the name of both farmers, which was represented by Phewa seed producing group of the Pame village, as well as non-farmer entities represented by local and international agencies, because these local and international actors were also part of the participatory plant breeding program. They designed the program, they invested resources in the program. So both farmers as well as non-farmers were the registrants of the variety under the law. But despite how the variety was registered, it got promoted as Nepal's first farmers variety. From 2006 to 2016, the Phewa seed producing group of farmers made significant profits from the sale of POKHARELI JETHOBUDHO seeds. The annual production of seeds increased from more than 3,000 kilograms to 10,000 kilograms, and then the price of seeds also increased from 35 to 170 Nepali rupees. Despite this, over time, the quality of seeds supplied by the Phewa group deteriorated, with claims from consumer farmers that they suffered losses. And consumer farmers and local farmers reported that there was the presence of significant amount of off-types and mixtures, and that the quality was compromised. Finally, a local NGO, which was a co-owner of the variety, decided to stop collaboration with the Phewa group and started to work with farmers from other sites to produce and sell POKHARELI JETHOBUDHO seeds. The farmers of the Phewa group are not, however, happy about this decision, which I discovered when I visited them in late 2018, around December 2018. So what this story tells us through this participatory plant breeding program is that there are certain questions and concerns that haven't really been taken into account when we talk about protecting farmer varieties as intellectual property, for example, in plant variety protection laws. And these questions and concerns are of many types. For example, like one of the first questions that probably would be very interesting for or relevant for debating further would be, do farmers really have the necessary resources in countries like Nepal or in Africa to develop distinct, uniform, and stable varieties for intellectual property protection? Because in the case of JETHOBUDHO, as you could see, because local farmers got support from local NGO and then the international partners, that's why they were able to invest time and resources from 1997 to 2005 to develop a composite variety of 6 lines of the same traditionally grown variety, So it really demands lots of resources. So do farmers have the necessary resources to develop those varieties for protection? That's the key question that I think the lawmakers need to answer and then understand. The second thing is, who is eligible to obtain intellectual property for farmers' varieties? Can farmers be defined to include non-farmer entities? Like in the case of JETHOBUDHO, the registrants of this variety were not just the farmers. There were also non-farmer entities like the local NGOs, and then the international actors who collaborated in that project were also the registrants. But will that be allowed under the plant variety protection law? For instance, the law that the India is implementing, is it allowed for farmers and non-farmer entities to collectively, own a farmer's variety and then register that for protection under the law? That is also a concern, I think, that needs to be addressed. The third is, what are the obligations of the owners of newly bred farmers varieties in relation to the use of tradition? So what we understand is that from category 1, that is from traditionally grown varieties, farmers develop newly bred farmers varieties. So what is the relationship between farmers who breed new farmers varieties with farmers who have been conserving traditionally grown varieties of the same variety? So because that is really important for us to understand, for instance, in relation to whether or not like how the farmer breeders of new plant varieties, farmers varieties, should obtain prior informed consent or should conclude benefit sharing agreement with the providers of traditionally grown varieties. So that is also a key issue that I think, and that has so far been overlooked in many of the laws and in many of the practices. So what kinds of exclusive rights do farmers need to commercialize their varieties? That is also a key issue, because in the case of POKHARELI JETHOBUDHO, certainly the original registrant farmers of the variety didn't have any exclusive rights under the seed law. That's why after the quality deteriorated and they couldn't sell the seeds, that's why another co-owner like the local NGO collaborated with some other farmers to produce the seeds of that variety, and then the initial group of farmers who were the registrant of that variety were excluded from that process. It all happened because there was no exclusive rights for those registrants under the law. So should there be any specific protection period for farmers varieties? That is also a key question, I think, because if you look at these laws, then if we provide protection to farmers varieties for a certain period of time, let's say for 15 years, then what will happen to these varieties after this protection period expires? Because under the logic of intellectual property, they will have to enter the public domain space after the protection period expires. So do we really want farmers varieties to go into the public domain space after a certain period of time? That is also an issue that I think needs to be addressed. Likewise, should the rights of consumer farmers to receive compensation and to access protected varieties through compulsory licensing apply to farmers varieties? I think that is also a key question, because in the case of POKHARELI JETHOBUDHO, the variety that I mentioned, the farmers were not able, like over time, farmers couldn't maintain the quality of the seeds that were being sold by them. And there were so many off-types and mixtures. And then many consumer farmers reported losses. So in such cases, can we think of compulsory licensing provisions for farmers varieties? Normally we argue the same thing for British varieties, but then we never talk about the relevance of compulsory licensing provisions for farmers varieties. I think that is also an issue. And then finally, that is my last point, is that before we really talk about farmers' rights and farmers varieties, we really need to look into the law and say, who actually is a farmer we are talking about? How do we define a farmer? Because that plays a key role in what rights we frame for these farmers and how we identify varieties for farmers, like how we identify farmers varieties. So I think knowing the definition of a farmer or conceptualizing a farmer into the framework of law and into the framework of practice is going to be quite critical in the entire thing. Thank you so much.
Okay, thank you so much, Kamalesh, and you raised really important points and questions. So I like your categorization of varieties. Category 1 as indigenous varieties, and then category 2 as farmers varieties, and having different standards of protection for both. But then you say category 2 farmers varieties can meet the distinct, uniform, and stable condition. My question or my pushback to that would be, why does distinct, uniform, and stable have to be the criteria that we go by? Why does that have to be the standard? And we could go into that in our second round of questions. I acknowledge that there are different perceptions about Suriha's presentation, and I would invite Marianne at the end during her presentation to perhaps shed some more light of her perspective while she's making her intervention on Suriha's position on the protection of farmers' varieties in our capacity as a civil society, member of a civil society organization. So next we'll have Mr. Rakesh Agarwal, former Registrar General of Protection of Plant Varieties and Farmers' Rights Authority, India, and his topic is Farmers' Rights and India's Protection of Plant Varieties and Farmers' Rights Act, Law and Practice. Rakesh.
Thank you, Titi. Let me share my slides. Kamlesh has brought out many issues, and of course, I do agree with him. He brought out the issues like what happens to the farmers' varieties after the protection period is over. Really, it's a big question. So let me just start under this topic. India has enacted this law because India became the partner in this TRIPS agreement. And that was the reason that India adopted the sui generis system for adoption of this. Now, I'm not going to touch upon the Indian Act. I'm just focusing more on the farmers' rights. What are the farmers' rights? How they are being implemented? What are different provisions? So that's what I will just focus upon here. One of the key factors under the farmers' rights is that under this law, the farmers are entitled to save, as it is there in the Article 9 of the TT. They are entitled to save, use, sow, resow, exchange, sell, and share their farm produce, including seed of a variety protected under the Act. So the key factor here is even if a variety is protected, they have all these rights, but they cannot sell the branded seed of a protected variety. That's the exception. There are many provisions. I will touch upon those provisions under this Act. But before that, let us understand who is the farmer as per the law in India. So the farmer means any person who is cultivating crops by cultivating the land himself, or even if he's not cultivating himself, he cultivates the crops by directly supervising. So even if he's supervising the cultivation, he is also the farmer. Or even if he's not cultivating, even if he's conserving and preserving individually, jointly, or whatever way it is there, with any person, any wild species or traditional varieties, or adds value to such wild species or traditional varieties through selection and identification of their useful properties. So then they are called the farmer. There are different sections which are written there. Section 2K, J, and many more sections, subsections are written there. Now, once you define the farmer, then what is the farmer's variety? The farmer's variety is the variety which has been traditionally cultivated and evolved by the farmers in their fields. So we can have all the land races, all the cultivars, they fall under this farmers varieties category. And they have gone beyond this, and they have also included the wild relatives or land races of a variety about which the farmers possess the common knowledge. So they will be also qualified as the farmers variety. Now, if you see the main categories which are registered under this law, under the category of new, extant, and essentially derived varieties. So there is a very unique category which is known as extant category, extant variety category. And under this extant category, they have clearly indicated one variety category, and that is known as farmers variety category. Now, one of the confusion generally people have in mind is that once we say farmers variety, they immediately link to the extant farmers variety. So that means the subcategory of farmers variety under the extant category. Whereas in India, the farmer has been equated to a breeder. Farmer can be also a breeder. So farmer can file a variety under any one of these categories. He can file a new variety also. He can file a variety of common knowledge also. He can file a essentially derived variety also, because he has been equated to a breeder. So once we talk for the farmers variety, mainly it is the extant farmers varieties, but in the PPBFR authority, we also have many farmers varieties which are there in other categories also. Now, that's what I was just saying, that farmer has been equated to a breeder under this section 39. And a farmer who has bred or developed a new variety shall be entitled for registration in the same manner as a variety of a variety under the Act developed by any breeder, any scientist. Now, if you see certain provisions, the farmers have the provisions for the compensation. If any variety they grow and if it doesn't perform as per the expected performance, which is declared by any breeder at the time of registration, then farmers can claim the compensation for this. Farmers have the right for the benefit sharing, and this is defined under the section 26, and there is some defined period under which if the farmer, even after registration, if they feel that their variety has been used in some variety which has been registered, then they can claim the benefit sharing under this case in this law. And beyond that, even if the farmer is not going to claim the benefit sharing, on the farmer's behalf, the communities or some NGOs, they can also file at any point of time for the benefit of the farmers, benefit of the communities, any such claims. And if you see a very unique thing which has been given in the interest of the farmers is that the farmers are not liable to be prosecuted, because they are considered, if the farmer can prove that he was innocent at the time of infringement of any rights of the bidder, then they cannot be sued in any court of law. That is the shield given to the farmer. The reasonable seed price, again, a very good provision in the interest of the farmers. So this is under the compulsory licensing. So if a registered variety is not available to the farmers, sufficient quantity is not available to the farmers, or if the price is not reasonable, then they can again claim the reasonable price and sufficient quantity of the seed, and a compulsory licensing can be invoked by the PPBFR authority in this particular case. There are various provisions in the interest of the farmers, that the prior authorization is compulsory for the commercialization of the essentially derived varieties. That is inbuilt in this, and this is especially when farmers varieties whether they are extant or new, are used by a third party as source material for the development of any EDB, the farmers need to provide the prior authorization for its commercialization, and such process can allow farmers to negotiate the terms of authorization with the breeder, which may include royalties, benefit sharing, etc. Now, in addition to this, you can also see it is mandatory that the farmers' varieties should be documented, and the role of the contribution of the farmers may be documented through various mechanisms. They may be electronic, they may be catalogs, or whatever way it is there. It's a statutory provision to do such things. And for that, the role of biodiversity management committees, I think you may be all knowing that India has a very well established system of biodiversity management committees in each village, which are controlled by the National Biodiversity Authority, not ITPGRFA authority. So there is another authority which governs the access and benefit sharing of any genetic material. And they have the biodiversity registers, which collects the statistics, including the contribution of any person in the evolution or development of any plant variety in India. And that's a very good source for such claims for the contribution of the farmers when deciding any such thing. There are certain exemptions given to the farmers because, you know, for providing any intellectual property right, you have to have the dust testing, and farmers' varieties, the dust testing is relaxed. It is done only for 1 year at 2 locations. There are certain issues I'll just cover in my last slide. And if you, as Kamlesh was saying, the production period for the farmers' varieties is not specifically defined. It is for all, it is defined according to the different crops. So if there are trees, it is different. It is 18 years from the date of notification registration. If it is crops, it is 15 years. So whether it's a farmers' varieties or non-farmers' varieties, so the period is defined. The very good provision under the Act is also there in the favor of farmers, and that is to recognize the role of the contribution of the farmers in the past or the present or the future in the way of recognizing such farmers as the genome saviors, giving them the financial support through the award, and then just see how best you can conserve their varieties, how best you can help them, those farmers, through the local mechanisms, through the Krishi Vigyan Kendras, which are available in all the districts. All those mechanisms have to be seen, and that has really recognized till date around 124 such genome saviors. It's a big ceremony conducted every year to recognize such genome saviors. There are many community seed banks being established by authority under various provisions. You can see some of the diversity in the plant varieties by many ladies. This lady has been also awarded, and they are really genome saviors. Their seed is so famous that many farmers, they come to them and just request for the seed which such genome saviors they produce in the fields. The good thing is around 1,650 varieties have been registered so far in the farmers categories, and 2/3 of the varieties received for the registration for intellectual property rights. They have received around 11,000 for farmers varieties. So that's a very encouraging thing, that maximum varieties are under the farmers varieties categories. They have a gene fund also to support the farmers for this award, not only for this award, but also for benefit sharing, other things. So they are just deposited in this national gene fund, whatever comes through various means. And for giving this award, for giving, for recognizing the different farmers, genome saviors, the authority has defined 22 agro-biodiversity hotspots, and then they just map to which biodiversity hotspots a person belongs, and accordingly there are certain provisions through which such persons are recognized. Now I'll just take this my last slide. Maybe I take just half a minute more. So there are certain issues in the farmers' varieties which generally we come across. The first is that when you receive the varieties from the farmers, there is a lot of heterogeneity in the seeds. So the authority has decided to purify the farmers' varieties first, because one of the criteria is the uniformity also. And for that 1 year, the support is given to some regional center, some university to purify all those things. So to help the farmers. Then claims of individuals on farmers' varieties, that is really an issue. Sometimes the same variety is grown by more than one farmer or more than one community, but the claim comes only from the individual farmers. So those things have to be really resolved. And many NGOs, many CSOs, they are coming forward to help in such issues. Then benefit sharing cases. So that for that again a mechanism is in place in the authority, but such cases, because of illiteracy among the farmers, because of much awareness among the farmers, such cases are very rare to come to the notice of authority. Mainstreaming of the farmers' varieties, mostly it is questioned, it is asked that just by keeping the intellectual property right certificate, how the farmer can be benefited. It has been discussed time and again that the farmers' varieties can be mainstreamed, can be seed produced and can be made available with some subsidy. So the talks are going on how best the farmers' varieties can be mainstreamed.
Excellent.
And
thank you,
yeah,
Rakesh.
thank you.
I think we're wrapping up, so you could follow up in the discussion session.
Sure, thank you.
Excellent, thank you so much. So you've raised really important points about the different varieties that we can protect in India, and so new varieties, extant varieties, essentially derived varieties. You've talked about saving, reusing, exchanging farm-safe seeds apart from branded seeds. And then you've also talked about access and benefit sharing and the nuances in the different ways of protection available for farmers' varieties. And I think that you've raised really important questions, because India is a crucial example, you know, for countries that are seeking to have inclusive forms of protection systems. So thank you very much for that. Next, we move to Miriam Mayet, Executive Director, African Center for Biodiversity, and she's going to talk about farmers' rights and farmer seed systems. And I've also invited her to perhaps comment on the presentation by Suha as well. Thank you very much, Miriam. The floor is yours.
Thank you very much for inviting me to share some views on farmer seed systems, farmers' rights, and the treaty. So first to say, having been observing the expert working groups' deliberations on developing options for the implementation of farmers' rights over the last 2 years, and more recently at the end of August, I think it's become very apparent that the interpretation of the nature of the obligations, the legally binding obligations on the state, as set out in Article 9, is disputed by us in the sense that it has taken on a very risky and dangerous narrative that we believe is not in line with the intentions, objectives, and provisions of Article 9. So just to start from the beginning, to answer the question posed previously about who are we referring to when we talk about farmers? And I think we're very clear that we're principally talking about the farmers that are referred to in Article 9, local and indigenous peasant farmers, under whose stewardship the treasure trove of agricultural biodiversity is maintained, enhanced, and developed for the benefit of all of us in the world. Second, as Kent has already said, farmers' rights lie at the very heart of the treaty. For as long as these rights remain unprotected and unimplemented, the treaty has run and continues to run the risk of its legitimacy being seriously impaired. Now, coming to the disputed narrative. Article 9.2, in our view, creates legally binding obligations on the state to take legal measures to protect and promote farmers' rights, including but not limited to the provisions in Article 9.2a, b, and c. And we say this because of the wording of those provisions. And it's very clear that the intention of the drafters and the contracting parties is that Article 9.2 creates legally binding obligations on the state to take measures subject to national laws. And that Article 9.3, which speaks to the rights to save, reuse, exchange, sell, farm, save seed and or propagating material, refers to a safeguard clause. Now, what has happened over the couple of years, aside from our critique of the global nature of our economic systems, the trade regimes, the very, very limited space that states have to maneuver to implement farmers' rights. What has happened is that a particular interpretation of Article 9 has arisen. And this is that Article 9.2 speaks to principally the taking of administrative, technical, and or in some cases financial measures, but that these need not be anchored in law. So this is for us the first problem, and that this interpretation is that it's not a general principle of law that Article 9.2 creates legally binding obligations on the state. And so the narrative goes further, that what constitutes the implementation of farmers' rights entail exceptions in plant variety protection laws. These range from exceptions that UPOV 91 provides in Article 15 with regard to the private and non-commercial use exemption, and then the optional exemption in Article 15.2. But it also includes sui generis laws, such as those that India, Malaysia, Philippines, and Ethiopia have enacted. We argue that these exceptions do not implement farmers' rights. What they do is they safeguard and recognize these rights and allows political and legal space for a discrete regime on farmers' rights to exist. Further, the narrative goes on that exceptions in seed laws, commercial seed laws that allow farmers some space to use their own seed without having to go through the variety release and certification processes, amounts to the implementation of farmers' rights, which we dispute. The final part of the narrative is that registration of farmers' varieties, and I will speak to vocabulary and concepts of farmers' varieties, and what actually is in farmer seed systems, is that the registration entails the implementation of farmers' rights. So now what I want to do is go back to what Michael Fakhri said yesterday when he spoke about plant variety protection laws. And we are with him when he says that these are commercial laws that create economic rights that are enforceable through civil procedures and civil courts. These rights cannot be said to trump farmers' rights because these rights are human rights. They are linked to a bundle of rights that farmers have and exercise, including but not limited to the right to food. Now, going to Article 27.3b, which creates obligations on contracting parties to the WTO to take measures or to implement, to put in place an effective sui generis system around plant variety protection, what we note is that TRIPS does not affirm the supremacy of PVP regimes over human rights instruments. And that the point of departure for us is that the treaty must affirm the centrality and primacy of farmers' rights as human rights, as the first, the kick-off point. And I think that we have to be very clear that plant variety protection laws, whether they are based on UPOV 91, which is a very draconian system, imported from Europe, put together by developed countries, mostly breeders, imposed on countries in the global south in a very, very colonial way, including sui generis laws like those of India's, to not implement farmers' rights. The best that we can say for the India type sui generis laws, as I have said, is that they provide some safeguards for the potential exercise and more fuller articulation of farmers' rights in a discrete regime that recognizes farmer seed systems, and farmers' rights. Now, this does not exist, okay? India's laws, like Malaysia, all these laws, they have tried to provide some space for something else to happen, which still has to happen, okay? And I'm not dissing the India law. I think that the movements in India tried very hard to protect some political and legal space for the future implementation of farmers' rights, which, as I said, still have to be looked upon. So we say that neither these laws nor seed laws that provide exemptions or exceptions implement farmers' rights as envisioned by the treaty. Now, both seed laws and plant variety protection laws, as we know, are essentially about private commercial rights. These are underpinned by profit-driven imperatives. These are centered around commercial models that rely on economies of scale for profitability. And as we know, these are focused on specific breeds and monoculture varieties, and which support industrialized agriculture that is a particular model of production involving the use of agrochemicals and irrigation, machinery, and so on. So now coming to the issue of registration of farmers' varieties, which Kamalash spoke about extensively, I think that we need to be very clear on concepts. When we talk about varieties, we talk about principally commercial varieties that meet, in terms of commercial seed laws, the DUS requirements. In terms of plant variety protection laws, we're talking about protection there. Protection is different to registration. Now, protection is about intellectual property rights, and then registration of farmers' varieties, which is a discourse going on in SADC, is about allowing some space for farmers to be able to enter this commercial seed market. And so what we have seen is that the provisions in seed laws that allow farmers' varieties to be registered are not measures that implement farmers' rights, but they are rather designed to draw farmers into the commercial seed market. When we are talking about, and what Surya was trying to explain, is that in farmer seed, you have land races, germplasm, populations, seed exchange with neighbors. There could be seed purchased from the local market. Some would come in farm input subsidy programs, and there would be hybrid commercial varieties, maybe even open pollinated varieties coming from the commercial sector. But we must call seed in farmer seed systems seed. If farmers want to protect varieties and they want to enter the commercial seed market, then they have to comply with DUS requirements and maybe quality declared seed system shortcut for certification. But this is not what we are talking about when we talk about farmer seed systems. And I'll end here. What local and indigenous farmers are asking for and have been asking for a long time, and I don't think people misunderstand what farmers are asking for. And I don't think it's right for the industry to tell us we don't understand them. They don't understand them. I think we understand each other very well. And what indigenous people and local farmers, peasants have been clearly saying, that we have our own seed systems. We need our seed recognized, including traditional knowledge, where there's agency and autonomy, and we need this clearly respected, protected, and we need the state to take legal measures to anchor this in law so that it's not an unfunded mandate. So there's some obligation of the state to mobilize resources and human capacity, like public research institutions supporting farmers. And some of these elements could include recognition of forms of collective ownership of genetic resources, centrality of women's role and power over the resources. The support by the state should be a mandatory duty around participatory seed selection and breeding. It can't be program and project-based or ad hoc or cherry-picking. Some farmers are in and some farmers are out. Brazil under Lula and Dilma, before the right-wing government came into power in Brazil and destroyed everything that movements had fought for, put in place a very good system linked to public procurement programs that were in turn linked to nutrition security programs and local circular and solidarity markets for seeds and agroecological produce. And this is going in the direction of the implementation of farmers' rights. So I will end there and say that what really came home to us during this pandemic, when our governments took massive loans from the IMF and World Bank to provide bailouts to big corporates, to the companies. There was no fund, that global fund, that small scale food producers could access to assist them. And the pandemic is only one of many shocks that smallholder producers have had to face over a long period of time. And many of these are climate-related shocks that are in turn related to industrial agriculture and the greenhouse emissions emitted by that sector. So what I'm saying is that we're looking at a situation of gross inequality and inequity. We recognize very readily that 90% of seed used by smallholder farmers in developing countries come from farmers' own seed systems. We recognize that indigenous and local farmers conserve and maintain biodiversity, but we are unable to really, people are asking where are the examples of the full implementation of farmers' rights? And we have to say that this has not happened. And it's a very sad indictment on all of us on this planet. So I'll leave it there. Thank you very much.
Okay, thank you very much, Miriam, for your presentation. And I think you've raised really important points for us to ponder and to come back to in our discussion round. So next, I think that we should go just straight into the discussions because we are running out of time now. We have only about 27 minutes more. And I'll start with Kent. So we've had a few comments. So we have a comment from Burghard, but I think that that's more of a general comment. And then we have a comment from Mayowa, and he's asking that would farmers be ready to go through the process of registering varieties and potential litigation that may accrue from that, or just the hustle of not being able to meet the requirements for registration, for example?
Thank you very much. I think that question is probably more appropriate for Rakesh, since he's been a registrar of the plant variety protection and farmers' rights registration. So he probably has more hands-on experience in that regard.
Thank you. Thank you.
Your role is more on the policy,
Thank you.
The national level. Go ahead.
Thank you, Kent. In fact, I fully agree. that farmers on their own do not come forward to register the varieties. It is the civil societies, it is some other NGOs who are helping them to file the applications. In most of the cases, we have found the help by state agricultural universities or the science centers or whatever is there. So they help and they come forward. The second question is, yes, I agree that farmers also cannot come for any kind of litigation. That litigation also has to be filed only by someone who belongs to civil society or who belongs to NGO or who is from the government side. So they have to just help them keep a watch on all these things to help the farmers in resolving their cases.
Okay.
Thank you.
All right, great, thank you. And next question I'll pose will be to Salvatore. So can we think of making a legally binding clear distinction between germplasm and finished varieties to move forward together? And that question is from...
Can you say it again? What was the question?
The question is from Shashank Maurya, and I apologize if I do not pronounce this correctly. So the question is, can we think of making a legally binding clear distinction between germplasm and finished varieties to move forward together?
The term germplasm is a very wide one. It basically includes almost everything on which a breeder can put his hands. Usually, but in my opinion not correctly, we associate germplasm with what is held in gene banks. But actually, from a plant breeding point of view, everything that can be used in a breeding program is germplasm, including the crop wild relatives, which are increasingly used. So it's very difficult to make a distinction.
Okay, great, thank you. And next question is for Kamalesh. And the question is also from Shashank Maurya. How should we go about in strengthening farmers' rights as an IP tool, as a marketing tool, not just keeping their varieties for conservation?
That is a very interesting question. And in fact, as I mentioned, in my categories of legal categories of farmers' plant varieties, like category 1 being indigenous, local, traditional, native, land races, and all those varieties, and category 2 varieties which have been bred from local varieties and then can be, termed as farmers' varieties. So category 1 varieties would fall more like more like the varieties within which farmers would like to continuously use and conserve and exchange within customary seed systems, whereas probably category 2 varieties like the newly bred varieties that come through participated plant breeding program or even some other independent breeding programs together with breeders or some others may go for commercialization in the market, where they can be used, even they can be promoted with the application of some kind of intellectual property over them and things like that. So I think that is kind of
the distinction.
Yeah, the distinction, and I think that is what has to happen, because I really don't understand when people keep on talking about local, traditional, native, everything, and then they don't really create that distinction between what has been bred out of these varieties. Like that is really key to understand why farmers' varieties are so dynamic and evolving, and at the same time can be bred into, and then why farmers can also act as breeders. So that is something that really needs to be taken into account, I think.
That's great. And that also goes to Miriam's point about the importance of vocabulary and conceptualization. I think that we need clarity in that regard. Thanks, Regina, for your comment about soya's position. And you're saying that farmers need legal space to save, use, exchange, and sell farm-safe seeds, but also to register the varieties that they develop and to protect them. Thank you very much for that. The next question would be, why should, and that's from Dr. Sarah Olembo, why should farmers' varieties or farmers themselves be denied intellectual property rights, and why are they criminalized? Why is it that a treaty is yet to cover their work and their products? So, for example, if I guess to expand on this question, it is if farmers use varieties that are protected, why might they be sued for that? So we know that there was a case in India about the potato varieties, and I know that that was settled out of court. So, Rakesh, perhaps, would you like to take this question?
I think policy matter, let Kent speak. I can tell you about the case. The policy part, Kent can reply.
Okay. I think Kent and Rakesh are. Kent, do you want to say anything about farmers' rights and intellectual property rights, and perhaps just litigation that might accrue from that?
Not really, but of course, the whole essence of the farmers' rights to ensure that their interests and rights are protected, to save, use, and exchange the material that they have been involved in. They've been custodians of for millennia. The foundation being aware of, especially the legal, how it was entrenched in the treaties to act as a balance to breeders' rights as well, so that they can also have their rights fully legally protected and recognized, essentially. But because all depends on the national law and national context to implement those rights.
Okay, thank you, Kent.
In fact, today, if you are not having the intellectual property rights on the farmers' varieties, then it becomes very difficult to legally protect their rights, benefit sharing case, or whatever I just narrated in my presentation. So there's a legal protection that in case something is being misused by anybody, any breeder, without recognizing their contributions or something. So you have all the legal protections using this IP protection to provide all kind of support, help to the farmers.
Okay, thank you. And I think we've already touched on Shashank's point. It's about the conflict or the interrelations between access and benefit sharing and intellectual property. So he's asking, why should we use compensation, or why should we use access and benefit sharing frameworks instead of intellectual property rights? But I think that you've already covered that. So the next question here is from Regina, and it's for Kamalesh. So underlying your presentation is the question of whether and how breeders and farmers can work together to jointly develop local varieties. What is your opinion on how such cooperation can be organized? And can I invite us to please make the answer really short, so in less than a minute?
Yeah, I think I will be very succinct. I think I'll try to be. So I think that's a great question. In fact, how can I would reframe it as like, how can participatory plant breeding be best organized in favor of farmers and breeders both? So I think that at the outset, as I mentioned, in the case of Nepal, in the participatory plant breeding program, there was no initiative was made to obtain prior informed consent from all the communities who donated or who provided initial lines. Like 338 lines were collected from 11 different sites, but then there was no evidence of prior informed consent from all of the sites. And likewise, there was no benefit sharing agreements with any of the communities from those 11 sites. And finally, it was only one group of farmers from one site who was able to be registrant of the variety legally under the Seed Act. So I think if we look at how participatory plant breeding programs can respond to prior informed consent requirements, can respond to benefit sharing requirements, and can respond to also the requirements for protection of traditional knowledge, and at the same time the requirements for how intellectual property plays a key role in finally allocating rights for whoever are involved in the participatory plant breeding program after the registration of the variety, would be really useful for participatory plant breeding programs to move forward, I think.
Okay, thank you, Kamalesh. And next question goes to Miriam, and it's from Luigi. Guarino, and I apologize if I'm mispronouncing names. And the question is, given that you think that no current national legislation actually enshrines farmers' rights, what are the sine qua non for such legislation in your view? So what would you envision farmers' rights to look like?
Well, the first thing that will have to happen is that the current plant variety protection and seed laws would have to be amended, because, and the amendments would have to speak to those seed laws that criminalize the ability of farmers to use, to market, sell, exchange their own seed without having to go through variety registration and certification. And here I want to pause and say that farmers are really concerned about seed quality. And it's really a misnomer that a lot of our governments regard farmer seed as grain. Farmers want to ensure the quality of their seed. They're concerned about germination rates. They're concerned about moisture content. Salvatore will tell you that they are interested in breeding, as they've always been doing, and they want to produce agroecological products. They want to contribute to national food security, but they're unable to do so because our laws do not allow them, because of the economic structure of our food system. So that's the first thing that needs to change. Plant variety protection laws will have to change as well. We do not believe that any developing country should join UPOV 91. To do this is exceptionally detrimental to the implementation and recognition of farmers' rights. It's in a very draconian piece of regime, a law. And what it does, it anchors a particular political thinking about what farmers can and cannot do with their seed, all seed. Now, the rationale for PVP laws is really to protect one breeder against another breeder. And farmers have become the collateral damage in this kind of protection regime. So we think that in order to implement the provisions of Article 27.3b, yes, sui generis laws would have to be implemented with clear safeguard provisions to ensure the free use, exchange, sale, or propagating material of all farm safe seed on the part of farmers. And then we need to articulate a discrete regime that recognizes farmer seed and that entrenches the provisions of Article 9.2 in that regime, taking into account Article 9.3, including a discussion about alternative quality standards to allow farmer seed to enter the market. We cannot allow such an inequitable situation to continue, where only corporate seed is allowed to circulate at the national level. And farmers are completely marginalized. There's no support except for the good people and development funds that come in now and again to support farmers. You cannot operate like this. It has to be, it has to be fair and equitable so that all farmers can access it, not farmers maybe only working with Salvatore, and that's the point. And that resources have to be mobilized to realize this on the part of the state. And we need to really push very strongly for that. And that is why the work of the ATEC will be very important, to clearly articulate what are the obligations on state and to outline a framework so that they can begin to implement and protect the rights of farmers. I mean, we're emerging out of a global pandemic. We must learn some lessons. I mean, we cannot continue to marginalize the majority of peasants in the world. It's completely unacceptable.
Okay, thanks a lot, Miriam. And so from that point, if we're going to follow up, you mentioned that farmers' rights to save, use, reuse seeds is important. You've also mentioned the recognition of farmers' seeds and farmers' varieties. If I'm going to push further on that, what would the recognition look like? And I think this is what Luigi is trying to ask. What are the concrete terms of what would the recognition look like for you?
I think it would have to be, it would have to be in a regime. Recognition doesn't translate to intellectual property rights necessarily, right?
Okay.
I mean, you can't start off on the basis that we look at how we're going to protect farmers' rights through a commercial lens. And this is what we're doing. We're pushing everything in one paradigm of looking at how protection takes place. Farmers will tell you how the protection should take place. They may say we want community protocols. Farmers are socially and politically organized. They have their own groups, they have their own systems. These are vibrant human beings doing great things. They're not static people stuck in the pre-pandemic world. Even during the pandemic, they've been doing amazing. These are amazing people. And if you speak to them, they will tell you how their rights need to be protected. But to say that it must be through seed laws and IP laws, this is why we can't move forward.
Okay, thanks, Miriam.
Sorry, can I add one thing to what Mariam just said?
Okay,
because in
10 seconds.
Yeah, very quickly. In participatory plant breeding, one a very exciting moment was when, after 4 years of selection, the farmers have to adopt a variety, and the issue was the name. And going back to the issue of recognition, for them, the name, choosing the name was the recognition. So the name could be a prominent farmer, could be the village, could be the son of a farmer, but the recognition was to have the possibility of naming a variety.
Okay, excellent. Thank you. And the next question will be for Kent. So is it possible, and the question is from Musamba Mubanga from Zambia, and the question is it possible for the treaty to make it legally binding for each country to define farmers' rights and how they support the implementation of the treaty?
Sorry about that. I was getting a call from headquarters. That's why.
Okay,
to take that. Sorry, can I get a question again so they can?
Okay, I apologize. The question is from Musamba Mubanga from Zambia, and the question is it possible for the treaty to make it legally binding for each country to define farmers' rights and how they support the implementation of the treaty?
I wouldn't say so. I mean, of course, the treaty itself in general is a legally binding agreement, but then it also stipulates that when it comes to farmers' rights, is within the purview of the countries to actually do the implementation. It leaves that to each government. So essentially, because the treaty is binding, so the countries have to, the governments of contracting parties have to, within their own laws and system, determine and define farmers' rights. So the central governing body cannot impose any definition as such on the countries.
Excellent, thank you, and apologies for cutting short your conversation.
No, I'm sorry. I should not have that.
Thank you. So the next question is for Salvatore. Can we not say government should become the custodian of intellectual property rights for farmers' varieties? And should the government identify and select promising farmers' germplasm and take them to plant variety protection offices as farmers' varieties for converting into intellectual property rights?
Well, I think that question can be rephrased as, shouldn't we consider seed as a common good? Isn't it?
Okay.
And try to avoid as much as possible to be privatized. I think Mariam said it very clearly that some of the seed laws are meant to protect breeders, and then the farmers have been a collateral damage. But yes, I strongly believe that the public should intervene on protecting farmers, because farmers always consider for 9,000 years, they've been managing diversity, and in the system of managing diversity, seed exchange, free seed exchange was part of the game. And there was no property. I mean, consider that in Ethiopia, I think not long ago, a lady, when gets married, she will bring with her the seed, some of the seed of the village. So the seed has such an important meaning, which is far beyond its commercial value.
Okay, excellent. Thanks so much, Salvatore. And the next question will be for Rakesh, and it's from Luigi Mayowa Ulubi. Just a combination of the questions, and I'll ask it as, can farmers' rights be applied retroactively? And can farmers be organized as a group? So a group of farmers, can a group of farmers or a farming community have the protection systems in India, as an example?
Yes, that is true. The farmers' rights are for a group of farmers. Farmer doesn't mean individual farmer. Farmer means group of farmers, community of farmers, and across those communities can also go beyond one district. So it is for the collection of, for the group of farmers. And the second question is, the second part was, what was the second part?
Retroactively, can farmers be granted?
No, retroactively it cannot be. The day you apply, from that day only, prospective date you can apply. Not.
Okay.
Yes, partly I can say, because if some farmers' varieties are there and somebody gets registration on this, so the past contribution can be claimed in the way of benefit sharing and communities compensation. So in that sense, it can be retroactive.
Okay,
thank you.
Excellent. Thank you so much. And the next question is for Kamalesh. It's from Professor James Gatti, and it's, so I like the concept of participatory plant breeding because it embeds within it and recognizes the agency of farmers as innovators, along the lines of the farmer from Nepal who spoke so eloquently about the very innovative work they're doing. Participatory plant breeding also sounds distinctive from concepts such as collective rights, which suggest inaccurately, in my view, that farmer innovations cannot be characterized as rights, and therefore inaccurately assuming that such innovations are open to appropriation along the lines of the discredited common heritage concept.
That's quite a long question, but I think personally, if you ask me, then I don't agree with the idea that there cannot be any rights for farmers, because every time I have visited farmers and talked with the communities about their varieties, I have always noticed that they always want to benefit from their varieties. And these benefits do not come automatically. They need to exercise some kind of privilege, some kind of rights, so that they can benefit from what markets the present world has created for these communities or for everyone, all of us, you know. So I think there should be some kind of mechanism for the recognition of their rights. But at the same time, I also would like to emphasize that it is not necessary, or it is not binding, or it is not compulsory for us to say that we must, you know, be embedded into the concept of intellectual property to recognize these rights. There could be so many other ways to recognize rights and reward farmers. And that's why I still like to, before I conclude, I still would like to re-emphasize my own thesis that we really need to understand farmers' varieties and their dynamics. And that's why I try to conceptualize them into two different categories.
Okay.
And then that relates with what Agrawal also said, is that in India, for instance, even if farmers' varieties are not registered under the Plant Variety Protection Law, I think those varieties are still protected under the India's Biological Diversity Act.
Okay, excellent. Thank you. Yes. So final question, because I know we've run out of time totally now, is for Miriam, and it's from Ice Segin, and it is, do you think it is possible to differentiate the commercial sphere and the farmers' sphere to implement farmers' rights? And wouldn't that limit the farmers' space to implement their rights? In 30 seconds, please, Miriam.
I think these are two competing and very different worlds. As I said, that the best we can get is some exceptions in commercial seed laws that allows for a discrete regime legally binding national regime that recognizes, protects, and implements farmers' rights. But for as long as we join UPOV 91, we have draconian seed laws. We're pushing farmers to register varieties that meet the UPOV DUS requirements. We will never get anywhere near to implementing farmers' rights. And we can't wish away the commercial seed sector. They have a role to play. However, what we are saying is the current situation is grossly inequitable, and there are strong imperatives on the state now as we come into the recovery period. We're still in a pandemic, to really show the political will, start a very serious and strong process of consultation with farmers, and then begin to really put in place legislation to make good on their obligations that they have undertaken when they joined the treaty. I think that they are doing a disservice to the treaty and to humanity for as long as they do not take their obligations seriously to implement fully Article 9 by taking legally binding measures.
Thank you very much, Miriam. And I just want to end by thanking all of our panelists for this very fascinating, informative discussion. Thank you so much for your presentations. And I know that we have lots of more questions that we unfortunately will be unable to take because we've completely run out of time. I would perhaps invite the panelists, if they would kindly do so, to reply these answers in a written form. So we'll collate the answers and I'll send them around to you, and we could share them with the participants in the reports that would follow this webinars. I'd like to thank the treaty, the Secretariat of the International Treaty, for the support with organizing this event, with providing the platform and the technical background for the event. I'd like to thank my colleagues at Afronomics Law and Flora IP for their support. I'll thank Professor James Gatti, Professor Labisi Akinkugbe, Professor Ohio Omino, Precious Adebanjo, Damilola Babade for their support, my colleagues at the University of Aberdeen School of Law, and just all our panelists from yesterday and today. I think that we've raised, very crucial topics and conversations that we cannot exhaust on this platform, and I hope that we will carry on the conversations in further work that would be engaged in. I'm working on an edited book collection, and I hope that we'll be able to put together some of our thoughts in that. And if anyone is interested in contributing to that, please feel free to send me an email, and I'll include you in our discussions on that. On that note, I'd like to close this webinar series and to thank all of our participants as well for your engagement and your very important questions. Thank you all, and I look forward to continuing these conversations in the future.